Hey everybody, my name is Ethen Ostroff. I am a personal injury lawyer with the Ostroff Law Firm. Today we are talking through the personal injury lawsuit process. Before I dive into that, make sure to hit that subscribe button. Follow along where I will make sure that your future personal injury case is protected. Nobody ever imagines that they're going to be a plaintiff in a personal injury case. I want to make sure that you don't put yourself behind the eight ball on situations that you really shouldn't. So, personal injury lawsuit process. Let me explain the nuts and bolts so that you can understand what's going on with your case if you hopefully not, but are going through something like this. So in terms of getting your case started, the first step you would do, obviously, hire a personal injury lawyer. They take your case, wait for you to finish with your treatment, or at least at the point where you have reached maximum medical improvement. And at that point, let me make this clear, this is not actually a part of the lawsuit, but it's the precursor to it. And I'm going to just go through this as quick as I can. They would submit a demand package, That demand package itemizes your medical records, and it says, my client went through XYZ. I'm asking for this much money. If the case does not resolve at that point, then you sue. If the insurance companies are being unreasonable with our position as your attorney, then we sue. The process of how that looks is we file something called a complaint in the county where either the defendant was from or where the crash occurred. And you file something called a complaint, which outlines sort of what we believe went wrong and why it went wrong and who's at fault and what we are claiming legally was wrong with this situation. And we need to actually go through a service process of that complaint. The service process is a little bit like what you've seen on TV. A sheriff will knock on your door and literally serve you with that complaint. At that point, when all the parties involved in the lawsuit have been served, then they are aware that they are a part of a lawsuit. Then you start something called the pleadings process. The pleadings process. A pleadings process is where you go back and forth, where we plead that something went wrong. Then the other party gets an opportunity to either admit or deny those pleadings. And once that process is done, then you sort of start the lawsuit. The next few steps are something called discovery. Discovery. It is kind of like what it sounds like. Discovery is where the parties get an opportunity for different types of question and answer sessions. Some are written in the form of something called an interrogatory, where one lawyer will ask the other parties and the other defendants, or the defendant's lawyer will ask the plaintiffs, a list of questions that we need to actually write answers in. If that process goes through, then there might be some negotiation back and forth between the parties. If the case still isn't resolved, you move to something called depositions. Depositions. A deposition is a question and answer session under oath where every party involved has the opportunity to be examined under oath, and that's just like it were in front of a jury and in front of a judge. There's a stenographer there. They will make sure that everything is actually written into a transcript. And that deposition, that question and answer session, really gives the lawyers what they need to set the case up for trial. Any testimony that happens under deposition is under oath, just as if it happened at trial. So that transcript is then given to every party involved. And you take that deposition transcript and you can sort of point to things that people say when you go to trial. Oh, you admitted to this thing then, but now you're denying it now. Where's the discrepancy? And you can attack people's credibility, and you can make sure that the case is set up properly for the jury to come up with a proper analysis. Once you have finished with depositions, the next step is when experts are due. So, if you're having a doctor testify as to your damages, if you are having a liability expert testify as to who was at fault, all those expert reports are typically due right before trial. Sometimes between expert reports and the actual trial, there's something called a mediation. Now, a mediation is not required. A mediation is where all the parties get together and try to resolve the case before it goes to trial. A mediation can actually happen at any point, but it does tend to happen right before trial a lot of the time. All right, now, just like you've seen in the movies, trial starts. You show up to a jury trial. It's in a county courthouse. Let's say in Philadelphia County is where your case was filed. You show up to the courtroom. There's a bunch of people who are waiting to be pulled from the jury. You pick the members of the jury that you don't want on the case in something called voir dire. Voir dire is sort of like the process of weeding out jury members that you don't believe you want on that jury for your case. It could be sometimes in a way that you remove somebody using something called a strike. Some types of strikes, you don't need to explain why you're taking somebody off that jury. Some types you do need to explain. For example, it's either for cause or it's not for cause. And some of those that are for cause, like let's say that somebody had a vacation planned or they have a medical reason they can't sit on the jury for a few days or a few weeks, they can be excused by the judge for cause. Others are called preemptory strikes. Preemptory strikes are you don't really have to explain why, but you can kick someone off that jury. Once the case goes through voir dire, the actual trial starts. There's opening statements, there's closing arguments, there's witnesses, there's basically the entire trial from start to finish, from opening statements to witnesses to the other party getting the opportunity to do the same thing and choose their witnesses and do their opening statements. Then there is a closing argument. Then the jury actually renders a verdict. They come up with a decision. For example, in a car crash case, they decide who was at fault. Let's say that somebody got rear-ended. You're going to win there if you're the plaintiff if you got rear-ended. Then question 2, damages. How much is the pain and suffering worth in a dollar figure? So that's really the nuts and bolts. In terms of a courtroom structure, the jury is in charge of determining the facts and coming to a verdict. The judge is in charge of determining the law and to make sure the lawyers don't actually break the law of the courtroom, which is called the rules of evidence, while the trial is going on. So that's the basic nuts and bolts of how litigation works. If you ever have any questions, I hope you never need a personal injury lawyer. I'm here for you. Click that subscribe button. And thanks so much for joining us today.